Okay, so before I start talking about Maddie, I want to bring to everyone's attention this little girl, Claire Bell, because this could be quite an urgent case. Claire Bell has been missing from, this poster is wrong, she has been missing from Quebec since the 15th of June. It's quite a disturbing situation, really. Her mother went into a business, not a police department, a business, and told them that her daughter was missing and she didn't know where she was. That's about all the information she had. This business was about an hour's drive, 50 minutes drive from her residence. They were last seen at the residence probably about 4 hours, about 4 or 5 hours beforehand. So there's a huge gap in time. There's a 50-kilometre distance between the home and where this mother went into the business and said, I can't find my child's missing, I don't know, I have no idea what's going on. And on the highway between the two locations, they have located the child's dog deceased. So it is an extremely alarming case. I have done a video about it, which I've just dropped a few minutes ago. If you wanted to go see that, wanted to check that out after this video and get more details. But it seems to me they have not been able to issue an Amber Alert because they cannot tick off the boxes for it. So it seems to me that if there is an abduction that has occurred, then without an Amber Alert, without an Amber Alert, the only way of getting the story out there is for as many people to share it as possible. I really haven't got a take on this case yet. I need more information before I can really figure out what the heck is going on and what I think is going on. So let's move on and talk about Maddie. So as you would no doubt be aware, Stearns' defence team, rather than putting in time to prepare for this first trial that is coming up on the 15th of July, they instead spent a bucket load of time writing and filing somewhere in the vicinity of 70 or 80 motions for the second trial, which of course isn't due to start till much later this year. The ridiculous part is that most of the motions are complete utter BS anyway, so complete utter waste of time writing the motions. I've already spoken about them several times. I've done several videos where I have discussed various motions that have been filed by Stearns' team. And of course, if you've been following my content this week, you will know that the state has now filed responses to many of these motions. So far, I've covered the state's response to the defendant's motion to allow witness statements for Stearns' parents so that they can tell the jury how much it's going to impact on them if their son is sent to the same place that Bundy was sent, if you know what I'm talking about. YouTube doesn't like you talking about these kind of things. And then, of course, there was also the motion where essentially Stearns wanted to be able to present as a mitigating circumstance this apparent head trauma that he experienced which, come on, was no more than a concussion, if that. He wants to be able to present that as a mitigating circumstance during the sentencing phase, but he doesn't want the state to be able to have their own expert witnesses to basically refute what his own witnesses would say. In other words, he doesn't want the state to be able to argue back when he says, I need mitigating circumstances, well, I need to be considered for mitigating circumstances because my brain doesn't work properly. Now, we know his brain doesn't work properly, but that's got nothing to do with any kind of head trauma. That's to do with the fact that his parents enabled him his whole life, and the guy is a somewhat narcissistic sociopath. I'm pretty certain that they don't count as mitigating circumstances. Now, if you have seen the last 2 videos that I did with responses to those, you will see that the state have brought out the best, and they have had Will J penning the responses to these motions. And that is the same with today's motion that I'm going to talk about. Now, I have said that I'm not going to be covering every single motion and every single response, but there are some that are just so significant, like this one and the 2 that I've already covered, that I think they do deserve to be covered individually. So, a quick rundown of this one. Basically, Stearns filed a motion where he basically said he didn't want the jury to be given any evidence or any statements that may create sympathy towards Maddie. Likewise, he didn't want any evidence or statements that may vilify him. Yeah, I'm thinking exactly what you're thinking. Like, hello? Why do you think you're in the courtroom in the first place, dude? I mean, seriously, Maddie deserves her justice. And to get that justice, the jury need to know all about Maddie and all about what she went through, all about what her life was like. And that is going to create sympathy for Maddie. The only way you could avoid that is by not actually discussing Maddie, which kind of doesn't really work in this case. As for not vilifying Stearns, well, that would mean not actually telling the jury any of his actions, not telling the jury what happened to Maddie, and surely not having any witnesses either. So I'm not really sure what sort of case you would have if you removed all that. Aside from a very quick case of walking into the courtroom, just choose any jury because it won't really matter because they don't need to be able to make a decision on much, and say, hello jurors, this here is Stephen Stearns. We want to prosecute him. We would like you to find him guilty of these crimes. We can't give you any more information. Please find him guilty. While his lawyers would come up and say, Stephen's a nice guy. Don't find him guilty. Thank you. Case over. Jury wouldn't even make it back to the chambers before saying, well, okay, we can't convict him because we don't know what we're convicting him of. I mean, it's a joke. So, understandably, Will J has definitely responded to this motion by Stearns' defence team. And you can guess that obviously his take on this is this motion needs to be denied. So let's have a look at Will J's response. Before I do that, I should just point out this notice of appearance that was requested and has been sitting there for like 2 weeks has finally been filed by Stearns' lawyer, Alicia Smith. She's the one that we've seen so far in court, along with that somewhat arrogant male, and I can't even remember his name. That's how much of an impression he has on me. So this is just a notice of appearance. The undersigned attorney of the Office of the Public Defender, 9th Judicial Circuit, files this notice of appearance on behalf of the defendant in the above styled cause. This, of course, should have been filed immediately after the charges were laid against Stearns, as soon as he had representation. So it just shows you how ordinary his legal team is. So honestly, who even comes up with these ridiculous motions? We have here state's response to defendant's motion to exclude evidence or argument designed to create sympathy for the deceased or vilify the defendant. Like, what a joke. The defendant's motion is overbroad and vague. The entire case centres around the allegation that the defendant, Cade, a 13-year-old girl who viewed the defendant as her stepfather while sharing a bed with each other. There is no other optic except that the victim be viewed as sympathetic, and the evidence will vilify the defendant. I mean, really, what more can you say? The defendant never exactly states what types of evidence and testimony is objectionably designed to evoke sympathy or vilification. He cites Jones v. State, but never states what the case holds. Once again, seems like Stearns' lawyers really don't know what they're doing. For the court's edification, the holding the defendant is apparently citing is that the state should avoid using a family member to identify the decedent at trial. The state will be offering to allow the defendant to stipulate to the decedent's identification at trial. If he does not agree, the state will attempt to use a non-family member to identify the decedent as the person the medical examiner's office conducted an autopsy on. This appears to be the holding of Ashmore versus State as well. So basically what he's saying here is that when the autopsy photos are introduced at trial, that they won't be using a family member to identify the images and say that those images are Maddie, but will instead use a non-family member, which I would imagine is pretty much standard practice anyway at trial, because you wouldn't want to unnecessarily cause further trauma for a family member by having them stand up in a courtroom, look at a photo of their deceased child and say, yeah, that's my child. Can you imagine having to do that? We know that they didn't do that to Becky Paddy or Mike Paddy or Anna Williams at the Delphi trial. And I know that's a completely different state, but, you know, the point stands. You just wouldn't do that. Due to the state of the decedent's remains at the time of her autopsy, the state may have limited options in choosing a witness to identify the decedent. Okay, that just breaks my heart. The Lewis case cited by the defendant does not discuss sympathy or vilification. Lewis versus State, it does mention the golden rule: neither the state nor the defendant should ask the jurors to imagine themselves in the place of the decedent or defendant. Okay, well that's reasonable. That's still really got nothing to do with what Stearns was apparently trying to argue. 4. Roe and Hathaway cases hold that mentioning the decedent's family status is irrelevant. These pre-Furman cases bear little relevance on the current state of capital punishment, and the use of victim impact statements, and those cases ignore that one of the aggravators in this post-Furman world of capital litigation in Florida is the relationship the defendant had with the decedent. Florida statute, the victim of the capital felony was particularly vulnerable due to an advanced age or disability, or because the defendant stood in a position of familial custodial authority over the victim. So what he's saying here is that they've cited a case trying to argue that the family connection to the victim is irrelevant and shouldn't be mentioned. And Will J. rightly points out that actually one of the considerations in this case is the fact that the defendant was in a position of familial or custodial authority over the victim. So essentially their argument that family connections are irrelevant doesn't hold water, because actually that is one of the aggravating factors and one of the things that is taken into consideration with the choice to make this a capital case. Now, yesterday I said that I wasn't sure if Will J. was taking the mickey out of the defence with some of his responses to their motions. He cited a lot of precedent, and it seemed like he was basically mocking them. And I said, well, I'm not sure, because I didn't really closely follow the Sarah Boone case. I don't know his style, I just know that he is a brilliant attorney. But when we look at point 5 here, or paragraph 5, I think we can see that he is just a little bit taking the mickey out of the defence. The decedent is not required to be depicted as a 13-year-old girl living alone with no family. Like, duh. I think I'm going to enjoy seeing this attorney at work. I may even go and watch some of the Sarah Boone trial just to see how he operates, because I think he's going to be a real treat to watch. Paragraph 6. The defendant never elaborates on what evidence it is that objectionably vilifies him. Yes, well, I think that's because he wants a whole blanket immunity there for vilification, and would like to see all evidence that may vilify him excluded from trial. The rest of the defendant's arguments then relate to objecting to victim impact evidence. This evidence is permissible under both the Florida and United States constitutions. Therefore, the defendant's motion should be denied. Okay, I know I said I was only going to cover the one response from the state in this video, but I realised that we have 2 other motions that were filed by Stearns' team, which were basically along the same lines as this first one that we just covered, where he basically wants to prevent victim impact statements because, of course, he doesn't want them to make him look bad. So since the first response from Will J was relatively pain-free, it makes sense to continue and look at these additional responses from Will J, basically discussing victim impact statements. So the motion that was put forward, the first one of these that was put forward by Stearns's defence, was basically arguing that they wanted all the victim impact statements to be presented in court in the absence of the jury, because otherwise they would make Stearns look bad. Like, oh my gosh, seriously, do they even understand what's going on here with this trial? Do they understand why this trial is happening in the first place? Do they not understand the pre-sentencing phase? Anyway, since I figure that Will J will argue this better than me and explain this better than me, let's just jump straight into his response. So, State's response to defendant's motion in limine to require State to proffer any and all impact evidence. Argument. The defendant asks the court to require the State to proffer all victim impact evidence outside the presence of the jury. The defendant asserts this proffer is necessary because victim impact evidence has a high probability of unduly, unfairly, and unconstitutionally inflaming the jury, thereby making it impossible for the defendant to get a fair sentencing phase. Dude, you gotta be kidding me, right? Ugh, what a joke. Arguing further that the statutory definition of victim impact evidence is vague, ambiguous, and difficult to interpret, and is not considered an aggravating factor. Okay, I have to say that it seems like this is a popular argument that is being used by Stearns's defence in many of their motions. They're saying that things are, the statutory definition of things is vague, ambiguous, and difficult to interpret. Can I recommend that maybe they need to go back to law school and try and actually learn to interpret statutes? Although, that said, lucky for them, they have someone like Will J, who clearly aced law school and actually does know what he's talking about, does know how to interpret statute, and clearly has an IQ much higher than that of Stearns's defence. So in these instances, when they are finding these statutes to be vague, ambiguous, and difficult to interpret, he can do so for them. Now, I'd just like to say I'm starting to become more and more of a fan of Will J. The defendant has failed to cite to any law or authority in support of this motion. Way to go. Just make up your own law, shall you? Defendant's assertions are not only baseless, they are completely untethered from the remedy he seeks. A state may legitimately conclude that evidence about the victim and about the impact of the M on the victim's family is relevant to the jury's decision as to whether or not the DP should be imposed. And because Will J actually knows how to do his job, he cites precedent here. Payne versus Tennessee. The Payne court went on to note there is no reason to treat such evidence differently than other relevant evidence is treated. In Florida, the admission of victim impact evidence is protected by the Florida Constitution and is also specifically governed by Florida Statute 921.1417. Callis versus State, the Florida Supreme Court has aligned its view of victim impact evidence with the United States Supreme Court, holding victim impact testimony to be admissible as long as it comes within the parameters of the Payne decision. Wyndham versus State, nothing contained within the Florida Constitution, the applicable governing statute, nor any other authority of which the state is aware requires or supports the proffering of victim impact evidence outside the presence of the jury. So, Lizzie, I suggest you might have been better off staying a secretary, or whatever it was you were doing, before you decided that you were so smart and so good at understanding statutes that you might just go on and become a lawyer. Because how's that going for you? Defendants' contention that the definition of victim impact evidence is vague, ambiguous and difficult to interpret is similarly without support. Florida Statutes Section 921.1418 provides, once the prosecution has provided evidence of the existence of one or more aggravating factors as described in subsection 6, the prosecution may introduce and subsequently argue victim impact evidence to the jury. Such evidence shall be designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death. Characterizations and opinions about the crime, the defendant and the appropriate sentence shall not be permitted as part of victim impact evidence. In other words, basically, it is well and truly covered by law for victims to actually, victim impact statements to be made to the jury, which demonstrate the value of the deceased person, not just to their family, but to society. And sure, we can't have victims getting up on the stand and saying, I think Stearns is stinky, because that's really a little bit prejudicial and isn't really fair, even if it is the truth. Okay, so Florida Statute 921.1418, 2018. The statutory language provides clear guidance and limitations on the presentation of victim impact evidence in capital trials. This clarity and guidance are seen in decisions of the Florida Supreme Court interpreting this section of Florida law, meaning that everybody else understands it. What's your problem? The Florida Supreme Court has recognised that evidence of grief and suffering due to the loss of the victim is evidence of the resultant loss to the community's members by the victim's death, and therefore admissible victim impact evidence. The Cosby Court further noted that the Florida Supreme Court has consistently upheld 3 victim impact witnesses and affirmed the presentation of numerous photographs. Honestly, this is just the gift that keeps giving. In fact, the court has had little trouble interpreting the statute in a variety of contexts. See Hernandez versus State, holding the fact that the victim possesses characteristics or experience similar to that of others does not defeat a showing of the uniqueness of the particular victim at issue. Baker versus State, holding that family members' emotions resulting from the loss of the victim, including feelings of pain, anger or fear, are directly related to the family's affection for the victim and the impact caused by his or her death. DeParvine, concluding that the fact that more than one family member testifies about one victim does not make their testimony repetitive, reasoning that each member of the family is unique based on the role and relationship each family member has. Thus, Florida statute is not, as the defendant asserts, vague, ambiguous, and difficult to interpret. In other words, even a half-wit could interpret the statute. Sorry, am I snarking it too much right now? I do find it really frustrating, some of the motions that were put out by the defence team, because I think they are unnecessarily cruel. Any victim impact evidence would only be presented during the penalty phase, and therefore any emotional outburst would not have the same prejudicial effect as it would in the guilt phase of the trial. And we get that when we have judges basically asking witnesses to try not to become too emotional, because of course the guilt phase is about facts, not so much about feelings, although we will all have our feelings during that part of the proceedings, as will the jury, no doubt, but the idea is not to be prejudicial. The prejudicial effect would be less during the penalty phase and does not outweigh the probative value this evidence has according to the cases cited above. And I have to say, the next paragraph definitely demonstrates what kind of a classy guy Will J actually is. The state, however, agrees that in order to avoid any potential errors regarding the content of the victim impact statements, that the victim impact statements shall be prepared in writing and provided to the defendant before they are read to the jury, so that the parties can agree upon any necessary redactions and request the court to rule on any disputed portions of the victim impact statements before they are read to the jury. Now, obviously, that's not going to be a case of Stearns' lawyers saying, well, that's going to really anger the jury when they find out how much everyone cared for Maddie, so we don't want them to actually say these things. It's more about avoiding misinformation, avoiding anything that may be unfairly prejudicial. So it seems that Will J does like to play fair, even when he is surrounded by imbeciles. Okay, so wherefore the state requests this court to deny defendant's motion in limine to require state to proffer any and all victim impact evidence. Now, I have to say that the motions that have been filed by Stearns' defence give us a clear picture of where they feel they stand. Seems like they are convinced that Stefan will be found guilty, because the things they focus on essentially wouldn't be hugely important unless he were found guilty. So one of the things they do with these things that they are focusing on is they go at them from several angles. So one of the videos that I'll be doing will be covering their attack on the DP. Basically, they believe it's unconstitutional and a bunch of other things, and they're trying to get that off the table. Also, as you can see, they're trying to get victim impact statements off the table. And the other really significant thing that they are attacking is the jury selection process. These are all things that tell me that they are particularly nervous, first of all, about the jury, because they recognise that majority of jurors are going to sit through that trial, come out and give a guilty verdict. And of course, the penalty phase is important for them because that's where the DP comes in. Hence the reason they're now attacking victim impact statements. So we've already seen 2 motions from the state where they're trying to do away with victim impact statements, essentially. And here is the third. In this one, they're now trying to argue, or they have tried to argue, and Will J comes back at them over this as well. They're trying to argue that victim impact statements are unconstitutional. Look, I've got to say, as amusing as all this is, I have one major concern, and that is that I hope this is not setting the stage for an appeal based on ineffective counsel. Because of course the last thing we want to see is for this to just drag on and on and on. Now, yes, I will mention you will hear the chihuahuas playing in the background. It is just that time of the afternoon. Okay, so this one is State's response to defendant's motion to declare 921.141(8) Florida statute unconstitutional. And because it is a mouthful, I will refer to Florida statutes as opposed to just citing the entire statute like 921.1418, because otherwise this video will just go on forever and ever. Okay, so argument. Defendant's argument is contrary to established precedent from both the United States and Florida Supreme Courts and cites to no authority that would permit this court to grant defendant's request. In other words, basically, they pulled it out of their ass and they've got absolutely nothing to back it up. Victim impact evidence is, as a general matter, permitted by both the United States and Florida constitutions. Baker versus State, which we've already heard a few times now. Both the Florida Constitution and the Florida statutes instruct that victim impact evidence is to be heard in considering capital felony sentences in our state. While such testimony may be inherently emotional, the United States Supreme Court has recognised that victim impact evidence serves entirely legitimate purposes. Citing Payne versus Tennessee, victim impact evidence is simply another form or method of informing the sentencing authority about the specific harm caused by the crime in question. Brady versus State, quoting Payne, there is nothing unfair about allowing the jury to bear in mind the harm that the K caused, at the same time as it considers the mitigating evidence introduced by the defendant. The defendant fails to cite any authority wherein the United States Supreme Court or the Supreme Court of Florida have found the presentation of victim impact evidence to be violative, I haven't heard that before, of a defendant's right to due process under the 14th Amendment. The state is unaware of any such authority. Significantly, however, the Florida Supreme Court has remanded a case to the trial court for doing exactly what defendant asks this court to do. Okay, I'll see what Will J has to say on this one before trying to explain it myself. In Farina versus State, the trial court entered an order prohibiting the introduction of victim impact evidence. The state took a cross appeal of this decision and the court cited Payne in holding, on remand the state should be allowed to present victim impact testimony that comports with the dictates and of decisions from the United States and Florida Supreme Courts. And while it is true the Florida Supreme Court examines the presentation of victim impact evidence for due process violations on a case-by-case basis, the court has never found such evidence to be per se unconstitutional. So basically, there may have been instances when something contained in a impact statement may have basically been a violation of due process. Perhaps it was more of an attack on the person who is being sentenced as opposed to showing the impact of the loss of the victim. But they're saying, the court has never found victim impact statements to be unconstitutional. Ever. Let's keep going. Courtney impacted a great number of people in her short life, and the victim impact evidence presented was a fair summary of her uniqueness as an individual and the loss her death caused to her family and community. Therefore, its omission neither constituted fundamental error nor violated due process. Okay, so that's in Cozzy versus State. I swear Will J is just doing this to take the mickey out of the defence team. He's just coming up with precedent after precedent, really putting it up them, basically. Wheeler versus State, reviewing the law on admission of victim impact testimony and eventually holding, despite these reservations, the trial court properly overruled the general objection to victim impact evidence because we have repeatedly held that the United States Supreme Court, as well as our state statute, allows its introduction within limits. McGirth versus State. Although we recognise that in some cases, unobjected to evidence which places undue focus on victim impact can violate due process, this court has never drawn a bright line as to the number of permissible witnesses that the state may present. Perhaps acknowledging the weight of this authority against him, defendant also argues victim impact violates Florida's capital sentencing scheme and the Eighth Amendment. This assertion too has been expressly rejected by the Florida Supreme Court. In Wyndham versus State, the court addressed an argument which classifies victim impact evidence as non-statutory aggravator in an attempt to exclude it during the sentencing phase of a capital case. Wyndham 656, whatever. Addressing this argument, the Wyndham Court held it does not believe that the procedure for addressing victim impact evidence as set forth in the statute impermissibly affects the weighing of the aggravators and mitigators or otherwise interferes with the constitutional rights of the defendant. Since this decision, the Florida Supreme Court has only cited two and approved its holding in Wyndham, but it has also explicitly declined to recede from it. Copshow versus State, we've cited with approval our decision in Wyndham versus State, which upheld the admission of victim impact evidence and Florida's procedures for addressing victim impact evidence. Copshow has demonstrated that this rule of law has proven unacceptable or unworkable in practice. We therefore decline Copshow's invitation to recede from Wyndham. Citations omitted. Moreover, the court has rejected the argument that victim impact evidence is irrelevant under Florida's sentencing statute because it does not go to any aggravator or to rebut any mitigator. Cormody versus State, which once again cites Burns versus State. And he finishes off with, wherefore the state requests this court to deny the defendant's motion to preclude victim impact evidence. So basically, there is absolutely no precedent whatsoever which has seen the exclusion of victim impact evidence, and yet Stearns' team think they can get that achieved. And I mean, the thing is, before you even include Tyler, Tatiana and their families, the Soto family is pretty big. So clearly the defence is quite worried about what the jury is going to think when they hear impact statements from the various people connected to Maddie. I mean, Jen might need to employ an acting coach beforehand so that her impact statement actually sounds genuine. Sounds like she actually cared about Maddie. But I think we can expect that when we hear from Juan and when we hear from Stephanie, they are going to be quite impactful. I think no matter what, in terms of action or inaction from that family, there were people who did care for Maddie. They perhaps just didn't know how to show it adequately, or perhaps were kept in the dark by Jen in terms of what was going on in Maddie's world. So, somewhat ironically, now that the Chihuahuas have worn themselves out and settled in for a nap, that brings us to the end of this video. So, I think it would be fair to say that Maddie's definitely got some really good lawyers on her team. And I feel confident about justice being served. Of course, you never know what the jury's going to be like. But, I mean, part of that comes down to jury selection. And I'd imagine that is another area where we're going to see the prosecution make good moves in terms of their strategies when it comes to jury selection. So that brings us to the end of this video. Thank you for listening. If you are new to my channel, please subscribe. Also, please hit the like button, YouTube loves that. And of course, please leave a comment below. Thank you, and I'll catch you in the next one.
I've been